As Pat mentioned, my name is Bill Maurer, and I'm the managing attorney of the Washington office of the Institute for Justice. For those unfamiliar with the Institute for Justice, we're a public interest law firm dedicated to defending fundamental rights of individuals and protecting basic notions of a free society. One of the Institute's core issues is private property rights. And in that role, we are the nation's leading critic of and legal advocate against the abuse of eminent domain laws, and we represented Suzette Kelo in the case that bears her name, the infamous case that bears her name. And this afternoon, I'm going to be talking about trends in eminent domain law and eminent domain litigation. And this being the mid-afternoon, I'm sure that's going to keep you guys all awake. So first, a little background. What is eminent domain? Black's Law Dictionary defines eminent domain as the power to take private property for public use by the state, municipalities, and private persons or corporations authorized to exercise functions of a public character. In other words, to put that into English, this is the power of the government to seize your property and convert it to its own uses, as opposed to many of the governmental activities that we have been discussing this weekend. The power of eminent domain is constitutionally based. It is an inherent aspect of sovereignty. It has existed for centuries in the English system. It is, however, an awesome power, not in the sense of, wow, that's great, but awesome in its true sense, as in you really have to look at it with a sense of awe of just how broad it can be. And that is why in the early 20th century, the U.S. Supreme Court described it as the despotic power. Quite simply, it is the ability of the government to remove residents from their longtime homes and destroy small family businesses to achieve governmental ends. Because the power of eminent domain can be so destructive and is capable of being abused, the founders of this country recognized that they wanted to keep the power, they wanted the government to have that power, but they wanted to put it within certain boundaries. And they put two very important limitations on the eminent domain power in the Fifth Amendment. The Fifth Amendment to the U.S. Constitution provides, nor shall private property be taken for public use without just compensation. These two limitations are laid out in that very, very short clause. If the government takes your property, they have to pay just compensation. And more importantly, the government may only take your property to achieve a public use. This is the key protection, because you never get to the issue of just compensation unless you have a public use. Historically, public use meant things actually owned and used by, well, the public. Roads, courthouses, sewage treatment facilities, libraries, things like that, where people actually use them as part of their activities as citizens. However, particularly in the last 50 years, the notion of public use has expanded to the point where the public use restriction is actually no restriction at all. Property in this country is routinely transferred from one person to another in order to build luxury condominiums and big box stores. The Institute for Justice engaged in the first survey of the use of eminent domain for private purposes ever undertaken in this country. We looked at what happened between the years 1998 and 2002, 4 years. And we found that there were more than 10,000 actual or threatened condemnations for private development across the country. Unfortunately, the ability to transfer private property from one private owner to another private owner under the Fifth Amendment was given the ultimate endorsement by the U.S. Supreme Court in the 2005 Kelo versus New London case. In that case, the U.S. Supreme Court read the term public use out of the Constitution. It held that the government could take your property and transfer it to private individuals for their private use for the purpose of increasing the tax base or for economic development. As a result of this decision, every home, every church, and every business in the United States is now up for grabs to the highest bidder. at least according to the federal courts. According to a narrow majority of the court, the mere possibility that private property may make more money as something else and provide more taxes to tax-hungry bureaucrats is reason enough for the government to take it away from you. While the Kelo case is a disaster, both in legal and in practical terms, there is one thing the court did get right in it, though. States and municipalities are free to enact their own property rights protections. They can also make sure that the law that currently exists actually provides home and small business owners with the security that they can hold onto their property and the law does not improperly equate private use with public use. Thus, after Kelo came down, 44 states passed laws restricting eminent domain. Some of them were rather modest. Probably the most pathetic of them all was from my home state of Washington State, which passed a bill that provided that if the government was going to take your land, they had to send you a letter. Previously, you had to go and find it on the government website. That was the rule, and that was Washington's great reform movement. Fortunately, other reforms have been more substantive. 30 states tightened their definition of public use for public purpose. 23 states changed their definitions of blight, which I'll get into more in a few minutes, to require a closer connection to public health and safety and to diminish the ability of the government to condemn large areas of property based on the condition of a few properties. 9 states have given the right of first refusal to prior owners to repurchase property if it has not been used for the purpose for which it was condemned. These changes were welcome, and they consisted of both statutory changes and changes to state constitution. Nonetheless, eminent domain still generates some controversy here in the United States. And these are some of the issues that we expect to be talking about in the next few years. An area that continues to generate a lot of controversy are what I just mentioned, the so-called blight laws. Formerly known as urban renewal, these laws exist in many, many states across the country. And they arise from a philosophical fad of post-war America that viewed poor people as a disease. Eliminate where the poor people lived, and everything would be better. And indeed, the term blight is actually lifted from agriculture and was traditionally used to describe diseases that slowly destroy crops. In the 1950s and 60s, state and federal courts repeatedly held these laws did not violate the public use requirements of the federal and state constitutions because eliminating blight was considered a public use. But it's important to remember what we're talking about when we discuss blight under many state laws. When most people think of blighted areas, they think of neighborhoods that are afflicted with objective, concrete problems so serious that the property itself negatively impacts the safety or health of the surrounding communities. Included in this would be properties that were dilapidated, unsanitary, unsafe, vermin-infested, hazardous, vacant, or abandoned. However, the laws of many states do not limit the definition of blighted areas to such concrete types of problems. Indeed, in most states, the definition of blighted areas is so broad that practically every neighborhood in the state could be considered a blighted area. Under Washington's community renewal law, one of the standards for determining whether an area is considered blighted is something called diversity of ownership. Does anybody know what diversity of ownership is? That means if you own your house, and you own your house right next to it, and you own your house right next to it, that's blight. In other words, a neighborhood is blight. These are standards that are not standards, as we were just discussing a few minutes ago. And in light of the Kelo decision, some state governments bravely decided that they did not care what the people thought about private property rights and the outrage about Kelo. And they actually increased the use of blight laws. And these states include Missouri, New York, California, and ironically here in Colorado. California was the absolute worst in the country. California was awful. However, California soon was rescued by the most strongly protective private property rights hero of the last 20 years, Governor Jerry Brown. In 2011, and I'm not kidding, he is, Governor Brown in 2011 pushed through a highly controversial bill to dissolve California's out-of-control redevelopment agencies, and they really were out of control. They were just absolutely insane, which were not only abusing property rights, but they were also draining billions of dollars from the state's treasury by siphoning off property tax revenue. Governor Brown did this because he wanted the property tax revenue to go to the cities so that the state would have to stop paying money from the state treasury to keep the cities afloat. So he was right for the wrong reason, but nonetheless, very good job. And despite a full court press by the cities, counties, and the redevelopment agencies themselves, the governor stuck to his guns. I have very rarely seen a politician withstand that kind of public pressure and pressure from interest groups as Governor Brown did. He was really an absolute rock in this. And in doing so, quite unintentionally, ended the worst property rights abusing regime in the entire history of the United States, I would think. Another concern are jurisdictions that have restricted the ability of the government to condemn property, but expanded the number of agencies that can actually possess the power. In addition to redevelopment agencies, some states have authorized medical districts and military areas to seize property for redevelopment. Many colleges have received the ability to condemn property. Many private colleges have received the ability to condemn property for their own uses. And even though Governor Brown did away with the redevelopment agencies in California, unfortunately he pushed through a subsequent law to grant some redevelopment powers to relatively unknown agencies called infrastructure financing districts. Although the regime that these particular agencies will be operating on is nowhere near as bad as the redevelopment agencies existed under the old system. I mean, it is night and day between the two. Related to this effort are efforts to use eminent domain for things like stadiums and casinos. For instance, even though the Ravel Casino in Atlantic City has gone out of business, the city of Atlantic City and the redevelopment agency there are still trying to take land to support what is now an empty building. With every new stadium or casino program comes down, or casino proposal comes down, there is almost always a suggestion that the government should use eminent domain to clear out pre-existing homes and businesses, especially since these facilities are often constructed in light industrial areas or poor neighborhoods. Finally, one area that we have seen an enormous amount of activity, and we expect to see, unfortunately, a lot more in terms of threats to property rights, it comes from what is called transit-oriented development. In many states, light rail needs to have extremely dense developments near train stations in order to have even a chance of getting enough riders to keep the projects from being unmitigated disasters. Here in Colorado, the fast-track light rail system has been particularly aggressive in its desire to condemn property to build high-density developments. As more and more localities seek to add shiny new light rail systems, urban planners and environmentalists will continue to urge state legislators to grant transportation agencies the ability to condemn private property for private use. It is therefore imperative that everyone in this room closely monitor any discussion of transit-oriented development in your state and take steps to ensure that construction of light rail does not result in the destruction of private property rights. When the Supreme Court decided the Kelo decision, there was an immediate and strong reaction. Many states took important and necessary steps to protect home and business owners from eminent domain abuse. However, a lot of the discussion has died down. Time has passed. A lot of the outrage has faded. And it appears, though, that those who would abuse private property rights are beginning to poke their heads up out of the ground again. As usual, those who believe in property rights will have to remain vigilant to ensure that everyone who lives in this country, regardless of their wealth or living standard, is treated by their government with dignity and respect.
We will be glad to take questions. I think all four presentations were very interesting and informative. I'd like to ask Cornelia a question. Do you think Westchester County would be in this pickle with HUD and the federal government if it was comprised of all unincorporated areas, if it didn't have municipalities making up its entire land area like Yonkers, like Dobbs Ferry and so forth? If you didn't have these municipalities, would HUD have gone somewhere else? And you can speak into the microphone, and I don't know if you know the answer, but please feel free to give that a shot if you like.
Well, I'm not sure I understand what you mean. So if there weren't these incorporated municipalities?
In other words, if it was like counties usually are south of the Mason-Dixon line, like where I'm from in Maryland,
right.
We have very few municipalities. Almost all of our counties are unincorporated, and the counties have basically most land use powers are vested in the county governments, and that's usually the case in the southern states, and I'm kind of being a little generous in saying that Maryland is a southern state, but we don't have like where every inch is incorporated, like every inch of Westchester County is part of a municipality. I'm wondering if that's why HUD has been so obsessed with your county.
So that's interesting. So there are counties who do the zoning and not the municipalities?
That is the absolute rule in Maryland and Virginia and in North Carolina, for instance.
Okay, yeah, that's totally different, of course. So, well, perhaps. Who knows? I mean, certainly HUD miscalculated because they went after Westchester County, I think, for several reasons. Westchester County is a very liberal county, and it had a very liberal county administration at the time they started this, and nobody could foresee that a conservative Republican would become the county executive of Westchester County. Literally 2 months after they signed the settlement, there was a shock. There must have been a shock to HUD, and it really put a big red line through all their plans. So, but you never know. You never know what happens.
All right, thank you. I will go ahead and we have until, I believe, 3:30, so we'll try to take a few questions here. Go ahead, Mark.
Okay, my question is really for Mr. Maurer, but I'd like to finish Westchester real quick.
Go ahead.
The S3 came in 2 months after the 2006 settlement.
The mic is not.
2009.
Better?
Yeah, better.
Okay. S3 came in after the 2009 settlement. What happened is 2 years later, HUD came back in and said, we want to go outside of the agreement, just arbitrarily came into Westchester County, which is a wealthy county, and that's the reason why they were in there. Consequently, they then went, at least the way the story goes that he tells it, is that they went from 31 cities that they wanted to change in the affordable housing to the whole county, and they went from 750 at that time to 10,500 units that would cost Westchester County $1 billion to provide, which meant that Westchester County was going to have to double its real estate tax just to meet what the HUD wanted. So this is HUD thuggery, and Westchester decided to sue, and that's where they're at now. So that's really the end of the story. I was hoping you'd get to that in your conversation. But my question to Mr. Maurer is this. In Florida, in eminent domain cases, and I've been through a couple, the taker of the property, the eminent domain, the city or county or whatever it is, has to pay the attorney's fees for those that they're taking the property from. Is this just germane to Florida, or have you seen this in other states?
That's been some of the, is this on? Everybody hear me? That's been some of the reforms that have gone through. That basically the idea is that you want the person to be made whole after the just because the government needs their property. So a number of states have added changes to just compensation that include things like attorney's fees, fees for consultants, things like that. But even then, the problem with just compensation is that typically the the property owner will come in with a claim that my property is worth what it's actually worth. The city will respond, no, no, it's worth half of that. And then the judge will pick a number in the middle, and it's nowhere near, it's compensation, but it's not exactly just.
I guess just to follow up on that real quick, my argument would be that if the federal government or any governmental entity gets into an eminent domain case, they should be required to pay the attorney's fees for the other side. That way, the government doesn't get to come in and just say, listen, I can run this case for 35 years. I've got all your tax money, so you either give it to me now, give it to me later, settle, but I'm not going away. If the people who were being foreclosed on, or even the case in Wyoming with them going after the gentleman who had the grazing rights, if he had an attorney that could basically represent him that he could afford, then you fight the case to the end, which gets you to a solution or a conclusion. Most of these cases, as you well know, are it's sue and settle. And because they're the federal government, they'll go as long as they want before they have to settle. You have to take them all the way, and you can only do that if you can pay for your attorney.
Yeah, it's very much similar to, dealing with the IRS. They say you owe X. You say you owe Y. They have an army of auditors, accountants, lawyers. You have a pencil. It's, eventually discretion is the better part of valor, and you end up settling just to not have to go through this like long twilight struggle to get something that in the end the cost would be too great, a Pyrrhic victory in a strict sense of the word.
Thank you.
I have a couple of tactical questions, one for Cornelia and one for Mr. Maurer. But first, I just wanted to say that these are four of the best presentations I've ever seen in my life, and just you guys are really treasures, all four of you.
You need to get out more.
They were also the first four presentations I've ever seen in my life, so but they were really good. I'm like probably a lot of people here are from communities in the crosshairs. I'm from the San Francisco Bay Area, so we're in the crosshairs, of course. And for the question for Cornelia is Marin County is also in HUD's crosshairs, and I'd like to get just a little bit of a sense of a little bit more of how we can push back like Westchester has, and also in Marin County, individual citizens are getting threatened with significant legal consequences by the local quote-unquote so-called affordable housing advocates who are working with HUD behind the scenes. I think they all should be in jail, but for this kind of RICO kind of thuggery, but it's just a fact we have to deal with. And how can you push back on this? The question for Mr. Maurer is in California, there was SB1, which you're probably familiar with. It was a bill in the legislature that passed the Senate and the Assembly, slightly different versions, and Governor Brown said he would veto it. It redefines blight as inefficient land use patterns as blight, and that's suburban living and rural living. And Governor Brown said he would veto it, but I talked with a lobbyist who told me that the reason why Governor Brown, our property rights hero, said he would veto it is he was just trying to get a better deal for his special interests. And when he gets that better deal, he'll sign it. So, obviously we want to try to stop that, but we don't have any power there. When that passes, what do we do?
Cornelia, if you want to speak
Yes,
first.
right. It's very difficult to push back. Westchester, the Astorino administration has been suing HUD and the federal government one lawsuit after the other, and they have lost every single one. And if you look at the person who filed the original lawsuit against Westchester County, it's a law professor. It's a constitutional law professor who happens to be a Marxist, and he runs this nonprofit organization single-handedly. It's not really an organization; it's this one man. And when you look at him, he went to law school. He went to Columbia Law School. The judge, Denise Cote, who decided in his favor, and he got, or his organization got $7 million compensation, although his organization isn't even located in Westchester County. Denise Cote went to the same law school. You know, these people have the same mindset. So Westchester County is bringing these lawsuits, and they are being decided by judges who are on the same side. It's very, very difficult. I would love to talk to you and hear about your experiences in Marin County.
With regard to SB 1, that was proposed actually by the President of the Senate in California. So we're not talking about an effort that had no significant backing behind it. But I think that from what I can tell of Governor Brown is that his concern is not necessarily redevelopment, but TIF, which is tax increment financing. Tax increment financing is the great engine behind eminent domain abuse in the United States. And what tax increment financing does is that when they create a redevelopment zone, the taxes are for the municipality, the police, the schools, the firefighters, you know, the people that do things you might actually need in the government. Those taxes are frozen, so that you have the floor, and they don't get anything else. When the redevelopment comes in, and because California has a lot of these growth boundaries, even in poorer areas, the price of property shoots up. The increase, the tax increment, goes directly to the redevelopment agency. And what happened in California is that the municipalities and the schools were getting absolutely ruined by this, but there is a state law that required the state to make up the difference. So they ended up that the state treasury had to pay all this money to schools and to municipalities, and it said the treasury and the teachers unions and the firefighters unions at each other's throat, and that is just not how those people want to be all together and friendly. And so my understanding from Governor Brown is that the thing he will not permit is tax increment financing. And if you do not have tax increment financing, you could have the world's worst redevelopment law, as we do in Washington. We have a terrible redevelopment law. It's awful. We have no redevelopment burdens, really, because there's no tax increment financing. There's no impetus. There's no incentive for redevelopment agencies to either be created or to operate, because there's no money in it for them. So my understanding is that Governor Brown's line in the sand is no tax increment financing anymore. He has allowed these infrastructure financing districts to make an effort, and there was a thing called the Jobs and Economic Development Initiative earlier in California earlier this year, or the JEDI Act, that would have brought back redevelopment and mutated it into like a Hulk-like being that was just really, really awful, and it did not receive enough signatures. But I think that was the effort to sort of scare Governor Brown into moving off of the tax increment financing, and he just refused to do it. So maybe I'm giving him too much credit, but I think that when it comes to tax increment financing, which if you don't have TIF, you don't have redevelopment abuse for the most part.
Thank you. That was the discussion between TIF and TOD was not one that nobody in my experience had made it as clear as you just did, so thank you for that. Mimi, go ahead.
Yeah, I just wanted to give an update on the affirmatively furthering fair housing rulemaking thing. The Congress did pass a law to defund it. Senator Mike Lee has a bill in front of the Senate right now. It's Senate Bill 1702, and it would also defund AFFH. So if you're interested in this issue, call Senator Mike Lee's office and ask what you can do to help, because hopefully it'll be coming up in the next month or two for a vote in the Senate. Thank you.
Thank you. I think with that, we are, the Senate is, do you have one more? Okay. You'll be the, I'm sorry, go ahead. Yeah.
I just wanted to try and weave the four things together for a second because I see them as very similar.
Sure.
I didn't get to this section, but planners, architects, and the kind of people at HUD and what you're talking about have several very similar attributes. They believe that they possess special powers of prognostication, and I don't say this lightly. They actually do believe this because they believe in essentially, and planners, especially in that time period, you're talking about the British time period, there's a lot of great work done in historiography of architecture and planning in that area. They believed in the Hegelian theory of the zeitgeist. What that meant was certain people could see where history was going. And as such, they could pick the correct aesthetic, ethical, moral, planning, whatever it was. They possessed that capacity to do it. And you went to architecture school or you went to planning school to get that power. And the interesting thing about people at HUD, or what we're talking about here, is that when you have a group of individuals who believe that their particular views, by dint of some special power, gives them the right to force history into the direction that they know to be correct, now you have a significant problem. They mistake the notion of their governmental or prestige or professional power as being something that's granted by some cosmic authority, not the limited nature of what it means to make ethical decisions in the world. That's why these decisions are not ethical decisions. They're essentially ways in which you exercise your personal preferences through some kind of proxy power.
Thank you. Go ahead. I think you have the last word.
Okay. I'm from Washington State, and
you need to talk close to the mic.
okay, facing, doing a little battle with Sound Transit, and
Closer to the mic.
okay, the Sound Transit board wanted to run a line through Bellevue neighborhoods in the interest of TOD. The neighborhoods put up a little fight, big fight actually, for a couple of years, and I helped them with that. And we defined alternative alignments that would do the same job, even for less money, but they insisted upon sticking with that particular alignment because of the potential for TOD, which impacts a modestly priced neighborhood immensely. Now, there is currently, and they're proceeding to buy property. Now, there's currently an alignment that would put it into a tunnel that would immensely reduce the impact of that alignment, but Sound Transit refuses to address that tunnel alignment, even though we know that some of their own staff are recommending that they do that. Now, is there any option, alternative that we have under this condemnation action to force them to consider that alternative?
Not to give legal advice, but I wouldn't bet your house on it. Unfortunately, when a municipality condemns property, one of the things they have to demonstrate is not just public use, but they also have to demonstrate necessity. The problem with that, meaning that it is necessary to condemn this property for the fulfillment of the project. Unfortunately, most courts, view necessity as what's necessity is whatever the government says is necessary. And that's certainly the case in Washington State. We represented a property owner that owned a small family restaurant in a city called Des Moines in Washington. And the city of Des Moines had a great idea to redevelop the area. And because it's Washington, we have fairly strict restrictions on condemnation for private use. They decided that they were going to condemn the property, but they were going to put a road there, which is roads, public use. Everybody agrees that. They didn't need to put the road there. The small family restaurant didn't fit in with their vision.
No.
And the vision, of course, as you've pointed out, turned out to be a big, empty, unsuccessful thing because they didn't know what they were doing. But they actually had one of the people in the Des Moines government say to the planner, to the person figuring this out, I want you to make damn sure the road goes through that restaurant. And the Washington courts looked at that kind of just awful, abusive, nasty thing and said, great, that's terrific, do it again. And said, so the standard in Washington is that you only get, it doesn't matter if you can demonstrate that their plan is uneconomical, it would be better to go other places, that it would, and this is all around the country too, that it would be less disruptive, be less expensive, it'd be wiser, you wouldn't be building it over a fault in the tectonic plates. You could demonstrate all that stuff, and the courts will still say, whatever the government wants.
That's not encouraging, but thank you for the Randall, I think maybe you get the last word. Go ahead. Thank you very much. So let's have a hand for the panel.
We're making DVDs of the recordings of all the sessions. In the first few sessions, the DVDs are already available. We're selling them for $10 or $5 to members of ADC. There'll be 12 DVDs for the entire conference. We're selling them for $100 if you want to buy the whole batch, or $50 if you're a member of ADC. We also have a few copies of last year's, all the sessions, and that's the same price. We're now going to take a 15-minute break and then go into Rick Harrison, Tom Wambolt, and John Charles will be here. The Follically Challenged, Tom Rubin and Randall O'Toole will be in Sage, 2 rooms down. And Mark Gotts, Peter Singleton, and Catherine Kirsten will be around the corner in Juniper in 15 minutes.
I'm happy to volunteer, but it's up to you.
I don't know if there's a moderator for this one, but
I'm starting to get the mojo, so I'm happy to do it if you want me to.
Okay.